Hi, this is Rich Sierra, CEO of the Florida Small Business Legal Center. This is episode 3 of Business SOS Podcast. Thanks for spending your time with me. Today's kind of part 2 of the last session we did, the last episode, and we're going to talk about the topic of lawsuits. I spent a great deal of time talking last week about if you get sued, what to do. And I gave you some strategies on how to approach if you received a lawsuit. And I also discussed mediation as a viable alternative to try to resolve business disputes. There's also another coin to that. And another coin to that is what happens, if you want to sue someone for a potential breach. Let me just give you kind of a scenario that happened to one of my clients, and I'll go to some questions as well. So the client basically hired a software company to develop a custom software, let's call it CRM, to basically handle his leads, handle his sales management program, and it costs close to $50,000 to do that software. So they enter into an agreement, a scope of work. They signed it. My client gave the $25,000 deposit. And as they began to work at different milestones, and unfortunately the software was not up to par, it was not the software he was expecting. After many months of communication and trying to get the software up and running, trying to get the proper fields, the proper functionality of the software, it just didn't work. So my client, frustrated after 6 to 8 months that this project was not getting off the ground, he decided that it was time to just fire this company and hire another company to get the work done. So he came to me and said, "Listen, Rich, this company just didn't do their job. I paid $25,000 and out of a $50,000 contract. I do not want to pay them any more money. I had to hire another company to do the work, and I'd like to sue them to recover $25,000. So I said, okay. So the client's name is Brian. And I said, okay, Brian, we need to talk about some of the things here. And we're going to discuss, why do you want to have this lawsuit and whether or not it's to your benefit to do so, and the cost-benefit analysis of suing someone or suing the software company to recover $25,000. In terms of my rules of filing a lawsuit or my rules on litigation, when I tell my clients, I tell, litigation is a battle of resources. It's basically who he has the most resources, most likely will prevail in that litigation. So business litigation is different than other types of lawsuits. When you see the ads on TV about, accident attorneys advertising, there's usually a funding source. And the funding source is an insurance company. And they say no recovery, no fee, no recovery. You don't get, we don't get any money until you get paid. To a degree, that is correct in the type of litigation that is like personal injury, in which they basically sue, say in the case of a car accident, they're really suing the insurance company who's insuring the driver for that vehicle. In the event of a slip and fall, for example, on a premise or in a business, they might be suing the landlord or the business, but most likely there's insurance, the general liability insurance, that covers that. So in the case of business litigation, for the most part, and there are exceptions to everything, of course, for the most part, the parties basically pay their own legal fees. So if you're going to sue someone, most likely you have to upfront those legal fees, and the other side will have to also pay for those legal fees as well. So you don't see too many business attorneys advertising. In fact, I don't see any in my 18 years of practice saying no recovery, no fee, because it is very, very unlikely that will happen. So let me tell you some considerations. There's one more point I want to make before I move into the question that I want to ask, Brian, and talk about and do a deep dive into the considerations if you want to sue someone. Is that there are many contracts that have prevailing party attorney's fees provision. So you have that, and I tell my clients, they tell me, listen, my contract states that I can get, if I win, I get the attorney's fees. And I said, yes, but it's not that simple. Doesn't mean that you will automatically get the attorney's fees. What it means that you are entitled to request the court to give you attorney's fees as the prevailing party, and it's up to the court to determine whether or not the fees that you're requesting are reasonable after a fee hearing, for the most part, and then at the end of the litigation, you might actually get those fees. And as we talked last time, a litigation can take 18 months, 2 years. So it's very unlikely that an attorney in a business litigation context will agree to do a litigation on contingency, is what we call it, hoping that in 2 years later, the attorney's fees that come back. And of course, there are exceptions to every rule, but for the most part, talking about small business context, you're not going to see that. So let's talk about, in terms of what the question that I ask, in this case, Brian, about why do you want to sue? And that's my first question. Why are you suing? And I'm talking here about Chapter 8 of Business SOS. This is my book. And it's Chapter 8 really goes into great detail in litigation. So the question, why are you suing? You're suing because someone, a vendor in this case, did not fulfill their obligation, not fulfill the contract. So that's a good reason to consider suing. My next question would be, have you tried to resolve the matter without filing a lawsuit? What type of communication have you had with the other side? Have they offered you any money? And I said, no, they're not. They're saying they did the work, they met the milestones, they provided deliverables, we made change orders, and they said that the best that we can do is walk away from it, because if we sue them, they're going to sue us back for the remaining $25,000. So that's also a consideration as well. The other question is, who are you suing? Where is the software company located at? What do the contract states? For the most part, software companies have contracts. So Brian is located in Florida. So I said, let's take a look at the contract and see what the contract states. So the software company is located in California. So in the contract also states that any venue, any lawsuit, any controversy would be resolved in the state of California, the city of Los Angeles. So we have another consideration here. According to the contract, if we sue in Florida, most likely he's going to seek a dismissal because you signed a contract that states that in order for you to resolve this dispute, you got to sue them where they're located at, which is Los Angeles, California. So that's a consideration. In that case, he would have to hold local counsel in California to file the lawsuit, which is not a problem. Somebody can be retained there and they can pursue it. And I said, okay, so let's talk about, and he said, well, how much will that cost me? And I said, well, I don't know how much it'll cost in California, but I'll tell you what it costs in Florida. And we'll talk about that in a few minutes. The next question is the entity. This particular case, it is an LLC that owns the software company. So they easily can be found through the Division of Corporations. They have a registered agent. So it is easy to find a company. So it's easy to get them served. So that we're not going to have a problem with that. The next consideration, the reason I mentioned that is that in some cases, I've had situations where somebody brings me a contract, there's a dispute in a contract, and then I'm looking at the parties, and I'm looking at the entity and trying to find them, and the entity, believe it or not, cannot be found. And one word of advice that I'll give you is that if you're going to go into contract with anyone, just make sure that that entity exists. Anybody can now download a contract from the web, and basically just put an LLC next to it, and you have to do due diligence. Every time you enter into a contract with someone, just make sure that you know who you're dealing with, and the person you're communicating with has the authority to enter into that contract, which is another subject altogether. We'll talk about on another episode. So, because the person doesn't have the authority, then you have another issue. But also make sure that the officers are listed and you can actually find who they are. So, just a word to be wise. You want to make sure that whoever you're dealing with, you can actually find them in some type of public record, that the entity they're representing is the real entity, and whoever they say that they are on behalf of the entity, you can actually verify it. So it was a good idea. The next question is, what do you want to gain out of this lawsuit? In this particular case, you have $25,000 that you paid. You didn't get the return on your investment, and you want to recover that. You also might want to recover the money that you're going to spend in trying to get the project done through another vendor. So you have a clear criteria, and you also want to recover your attorney's fees. We talk about attorney's fees, that those are much later, if indeed you award them. You also have to deal with appeals. So it's not as easy as it sounds. The next question is, what is it going to cost me? And that's the question that, most common question I get when somebody is being sued or somebody is about to sue. What is it going to cost me? Okay. You have a $20,000 or $35,000 problem. In a lawsuit, you can spend, if it goes all the way to trial, if that's what you want to pursue, you can easily spend that much money taking the case to trial, depending how many depositions you have, how much discovery, how much motion practice do you have. And the analogy that I give my clients is like, listen, just think of a lawsuit as every time you pass through, a toll road. We have the Turnpike here in Florida. We have 995 now. They're doing tolls. So every time you go through that toll road, just think that $1,000 is going to basically be coming out of your account. And the reason is that 80% of litigation, especially at the beginning, it is motion practice. 20% is the facts. What happens is that what we see on TV, we see the TV shows that goes from something happening, go to trial. There's a lot of things that happen in between that it is very intense. It is about capitalizing on the other party's attorney's mistakes. And the analogy that I gave before in my last episode is like, it's a bar fight on paper. So you're not going to be unscathed if you feel that you're going to file a lawsuit and feel that every single thing that you do is going to go your way. It does not happen. And in my experience, there's no such thing as a slam dunk case. There are so many defenses, and contract law is very technical. And there are very many defenses to contract law, especially in a breach of contract dispute. So in terms of the cost, I said, okay, so initially you could easily spend $10,000 just getting your case off the ground when you're talking about preparing the lawsuit, filing it, and getting discovery. Most likely you will have the opposing side file a motion to dismiss if you can do it. And motion to dismiss is looking for technical errors in the lawsuit, which, it happens to me, happens to the best attorney. Sometimes we miss something and then they file a motion to dismiss. It can easily be corrected. and you go ahead and correct it. But the first thing we do is when we are filing a lawsuit, we basically, in my case, we test it to make sure that it survives a motion to dismiss. Because that's the first thing a defense counsel will do. They'll look at the lawsuit and say, okay, there's some errors here. We're going to file a motion to dismiss right from the very beginning. And there are two reasons for that. Number one, it pushes the other side back in a more defensive position. And number two, if you do not do it at the beginning, you waive it. So you have to do it right from the very beginning if you're able to file that motion to dismiss. So then you go ahead and say you survived it. The other side has to file an answer. So in the case of Brian, we basically hired local counsel. We went ahead and he said I wanted to go ahead and pursue it anyway. It's a matter of principle, which as I see in my book, I do not like lawsuits about principle because of the cost. But he felt strongly enough that he wanted to do it. So, okay, our local counsel, I was co-counsel. We basically prepared the complaint, got it filed. So the other side basically filed the answer and affirmative defenses, which clearly denials two of the allegations, but also filed a counterclaim against us. So when somebody files a counterclaim, you're basically being sued. And then you have to defend that lawsuit. So you have two lawsuits now. You have the lawsuit that you're filing, in this case against the software company, and then you have the lawsuit coming back to you, which now the attorney has to basically manage two lawsuits. The lawsuit that is being filed against the software company, and then the one that you basically are receiving that the attorney has to basically respond to. So we went ahead and answered the counterclaim, and then we issue what is called discovery request. Those are interrogatories, request for production, and request for admissions. And I'll explain what they mean. Interrogatories are what they are. They're questions that we send to the opposing side to answer questions on their oath. I like some of the questions. I like doing interrogatories. I'm not a big fan of them to the extent that very seldom I get an answer in an interrogatory that is as positive or will give me that aha moment and say, oh, you know what? Here's an admission that he gave me that I'm going to use in trial. Very seldom I receive that. But we send them anyway because we get information. And what I like to interact with is get factual information about witnesses, information about who has documents, information about clarification of some of the facts, or whether or not they have additional evidence. So those are good, but nobody's going to give you a confession on an interrogatory. It doesn't happen. Primarily because the attorneys will review it, and then the attorneys will go ahead and change some of the questions, not necessarily doing anything wrong, but basically they'll make sure that the question is answered correctly, but not to the extent that will affect your case. We send a request for production of documents. Those are basically a list of requests asking for the documents, any documents that in this particular case, a software company, that is basically a litigation. There's a lot of communication via email between the software company and also my client, Brian, and there may have Zoom calls that were recorded. So we ask for all that evidence, all that information. There's also people also do send a lot of text messages. Any documents that are related or relevant to the lawsuit, we request that. So, and also we'd ask requests for admissions. Admit that, yes, Brian, you enter into the contract, it is admitted. Admit that this is the scope of work. Yes, we get them to try to admit that they did not perform the scope of work. They'll deny that. But we send the request for admissions as well. During this time also, what we send is third-party subpoenas. There might be other witnesses that may have information on the case. In this particular case, the software company, we learned later on that they hire a subcontractor who really did not know what they were doing. So we basically, the subcontractor is a separate company. In this case, the subcontractor was in Florida. So we issued a third-party subpoena to provide us all the records regarding this project and all the communication they had with the software company, including their contracts, to be able to, prepare us, find out what information we can ascertain from them as well. So any witnesses, we send third-party subpoenas to get documents from them. Then we go into taking depositions. You get the idea how this can add up. You take deposition of witnesses and parties. So clearly the representative from the software company will have to be deposed. These are questions, the attorney will ask. They have to answer on their oath. And deposition can take sometimes 2, 3, 4 hours, depending on how long the material is, how much material we have to cover, how many topics. And the same thing will happen with Brian. They will have to be deposed as well. So during this particular time period, you're basically gathering evidence to support your case. There's a misconception that you got to have all the evidence available to file a lawsuit, and that is not true. You got to have the minimal allegations and a good faith basis to file the lawsuit, and the attorney will make that determination. If there's enough information available at this point and a good faith basis to file the lawsuit, it's the attorney's responsibility to say, I think we can move forward. But you don't have to have every single piece of document to prove your case when you begin your lawsuit. That comes later if it goes to trial. So the cost of something like this, just to give you an idea in terms of depositions, court reporters can go up easily $150 an hour just to appear at a deposition. And then you look at a transcript, a 2-3 hour depo transcript could actually cost about $500 or more. So you're talking about 4 or 5 witnesses or depositions. It can add up. $600-700 per depo when you transcript and the time, it can add up very easily to $4,000 or $5,000 plus the attorney's time. Throughout that time, we are not talking about something called motion practice, discovery. 9 out of 10 times when you get a discovery request sent back to you, you're not going to get complete information. There is something missing. There might be an interrogatory not fully answered. There might be a document not produced properly. So you try to work with opposing counsel to say, listen, I need these questions and these documents to be answered fully on all these documents to be produced as well. Or they might have an objection to a document. They say it is privileged, it is irrelevant, they don't want to provide it to you. So in this case, we need to go to the court, to the judge, through a hearing, to have the judge make a determination whether or not they'll go ahead and release the document or compel the party to answer the questions. And we still have not even gotten to really the facts about preparing for trial, which perhaps I'll do that in a separate episode. But what I want to give you an idea, there's a lot of things behind the scenes that go on in preparing for in filing a lawsuit and getting ready for trial that most clients do not know. All this work that I share with you is handled by the attorneys. The clients, unfortunately, don't have a lot of control of what goes on in motion practice, the discovery request that we're doing. Also, you will have discovery. Brian had discovery he had to do. So he had to answer interrogatories. He had to answer production request, all the documents. There's time that we have to go through in preparing for that to make sure we do our due diligence and answer it correctly. So it goes both ways. When you send information back there, a request, you're going to receive requests as well. So there's time away from his business that he had to spend doing this litigation. Remember, this is for $25,000. How long will this take? In my experience, cases are between 12 to 18 months. What I try to do is try to resolve them as fast as possible, simply because I know that it's going to be a financial drain and it's going to be an emotional drain, a psychological drain of the client, and Brian in this case, to really get through the 18 months. And in some cases, Brian had resources, so he certainly could have gone the distance. But in some cases, clients do not have a fund set aside for lawsuits. They just don't. You know, you're a business owner. You're working with, you're trying to get your sales, get your customers. You work with your credit lines. You have your cash flow. But there's very seldom a separate line item that says, okay, this is going to be for lawsuits. You might have a general counsel, you have an attorney, but, you know, I haven't had a client yet said, okay, I have a fund ready for lawsuits, here it is. It just doesn't happen because it's not something that is pleasant. It's not something that is really more of an event that happens because another event took place, a breach or you got sued. How much am I willing to settle for? That's another question. So Brian wanted $25,000 for attorney's plus attorney's fees. He said, I want my $25,000. I'm not willing to accept a penny less. That's fine. What I found is that when you're suing, if you want that exact amount, you will have to stay in that lawsuit. Most cases in business litigation settle for that reason alone, because it is a battle of resources, and at some point there's an opportunity, there's a risk analysis has to be made, a cost-benefit analysis has to be made as to whether the cost is worth pursuing. The loss is worth pursuing based on the cost. So, but he wanted $25,000. I respect that. I advised him maybe, we'll go to 15 and get this over with. No, 125. Okay, fine. That's his prerogative. And that's fine. Now, the other question that I ask, what is the cost of doing nothing? That's an option. It's not a pleasant option. I said, what if you break the contract, lose the $25,000, and move on? It's not an easy pill to swallow, but it's an option indeed. But I'll discuss it. What if you do nothing? What will happen? I'm not recommending it. I'm saying it's good to at least think about it. And these are questions, just to be clear, to make you think. And what I want to emphasize here is that the decision to file a lawsuit, and I do file a number of them on behalf of my clients, has to go through some analysis and some forethought, some thought. It should not be a trigger, I'm just going to quickly file a lawsuit. And it's not that simple as it sounds anyway. How much am I willing to lose? How much are you willing to lose in the lawsuit? Because in reality, there are no guarantees. No attorney can guarantee you success. They just can't. Because what happened is this: when you're filing a lawsuit, you're telling the judge or the court that we really cannot solve the problems ourselves. We cannot. We had a business arrangement. They breached the contract, but I cannot work with them anymore. We need a third party, in this case, the court, to solve it for me, solve it for us. And that costs money. And the decision that Brian had to make is how much is he willing to spend to get his $25,000. Another question that I asked, is there anything else you would rather use the money for? You're going to spend another $25,000 to try to collect $25,000. Does not seem to be a good business arrangement, but some people do it. But can you rather use that money for something else as opposed to filing the lawsuit? That's a consideration as well. So what happened here? So after everything, all the parties decided to do all the discovery, do the depositions. At least each side spent 15, 20 grand. Remember, for $25,000 on both sides. Then the court issued an order to require mediation, which happens very often. Excuse me a second. So we decided to go on a mediation conference, and last time I spoke on mediation in great length, but mediation basically is hiring a private, either a judge or or an attorney who's a certified mediator, a neutral party who has nothing to do with the lawsuit, to try to resolve the disputes in a confidential manner. So we agreed to mediator. We had a 2-hour mediation, went back and forth. The mediations are confidential, so we cannot discuss any terms. But at the end of the day, the matter got resolved through mediation. So what happens here is that most of these cases, after there's a lot of back and forth and cyber rattling by the parties and by the attorneys, they have this meeting and begin to talk about solving the problem. And my experience has been is that I'm a big proponent of early mediation in any business dispute. We don't have to have all the facts. We have the facts that we have right now, and that's sufficient to, at the very least, have a conversation as to solving the problem. And my experience has been is when the parties begin to spend time in a mediation conference in solving the problem, the thought process changes from let's fight it in court to let's try to solve this. And let's find a way to compromise. And compromise is very important in the process of negotiation. Because the reality is, in any type of business dispute, somebody lost already. So the question is, losing less, or if you're going to gain, but the party who's trying to gain is not going to get 100% of what he or she wants. The party that is going to pay is going to pay a little bit more than he or she expected to pay. Both parties will leave a little bit unhappy when there is a compromise between parties. But at the end of the day, when a case settles, a case gets resolved, the parties can go on to live their own lives. And this particular chapter of their lives, which is litigation, is extremely unpleasant. It is behind them, and they can move on to living their lives and running their businesses. So that's why I'm a proponent of early mediation. But also, the parties have not spent a great deal of resources in the litigation. And what happens sometimes is that when you have the mediation close to trial, which it happens in most cases that takes place, the parties are so invested in the case that they probably say, let's take our chances. And that's also a decision. But if you do it early, you don't get to spend the money that you would spend throughout the case. So it is a very important decision. Just to recap some of the questions, the questions to ask yourself if you want to, thinking about suing someone. Why am I suing? Who am I suing? Where's the entity located at? That's very important. What am I going to gain from this lawsuit? What is it going to cost me? How long will this take? How much am I willing to settle for? What is the cost of doing nothing? How much am I willing to lose? Is there anything else I would rather use this money for? Remember, what I'm talking to here cannot be considered as legal advice. Your situation is different and unique. But what I'd like to do is invite you to send me any questions, any legal questions you have, any business-related questions that you'd like me to address at the show. If I select your question, I'll send you an autographed copy of my book, Business SOS. It is available in Amazon, Barnes & Noble, and also the local bookstores. Another question is if you'd like to reach me, how can I be reached? So a number of ways. You can send me an email at richsierra.com. Also, you can visit my website at floridasmallbusinesslegalcenter.com. And Facebook, I'm at FSB Legal. We also have this podcast and video as well at Rich Sierra. You can just go to youtube.com / Rich Sierra. You also can call me at 866-842-5202. If you like the podcast, please follow us, the show. We're an Apple Podcast. We're at Spotify, wherever you enjoy your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.